and welcome to the VWV property update, coming to you live from, well, I think we're all over the country, as are all the attendees. So we have three great little talks for you today. First up will be myself talking about a bit about planning law. I'll be followed by Rory Young talking on the Leasehold and Freehold Reform Bill. And finally, Rebecca Hill giving us a general case update. As we are going along, please feel free to stick any questions in the question and answer box. They will pop up on various of our screens, but we will probably answer them at the end, if that's all right. And at the very end, at about 1:30, we'll have a feedback poll, which you can fill out as part of the session. So please all have your number 10 paddles ready. That would be excellent. So without further ado, let's move on to my little bit, please. So I thought I would talk about understanding a planning permission, maybe a little bit about the basics of the decision notice, and then have cover a few of the ways that one can deal with variations to planning permissions. So I will have a quick look at the scope of the development, the conditions, and the two major ways of making those variations. So on the next slide, we can see that a local planning authority is required to issue a decision notice on every valid application. That may surprise you if you have been dealing with councils, as they can be quite slow. The resolution to a delayed application, of course, is non-determination, giving rise to a right to appeal. But it is worth noting, as a matter of law, the decision of the council is contained in the notice. And that has to be, and it's not a valid decision until it is conveyed to the applicant in a formal document. That is the decision notice itself. So it's worth noting that a resolution to grant by the council is not enough for the grant of planning permission. An informal communication from the planning officer, like an email saying, oh, it'll be coming soon, that's not enough either. And there isn't a standard layout for decision notices. They do all look a bit different. That's not desperately helpful, but there are some mandatory contents, and we'll have a look at that in a moment. So the general principle for a planning decision is that the decision itself must be contained within, they say, the four corners of the notice itself. So that means that you're entitled to take the planning permission on its face value. Everything should be set out in the notice itself, and extrinsic matters cannot be brought in at a later date. And by extrinsic matters, I mean the application form, the supporting documents, plans, and other paperwork, and so on. They don't form part of the planning permission unless they are referred to in the decision notice. Now, the reason for this is certainty. Future owners and third parties should be able to understand what has been granted without having to ask further questions. All this is consistent with the usual English contract law and statutory principles. So there's nothing desperately unusual about that. And finally, on this slide, the issue of the decision notice is final. There isn't a power for the local authority to correct or withdraw it, which leads to a long line of embarrassing authorities where LPAs have issued drafts of decision notices or forgotten to include important conditions. It's too late once it's gone. So on the next slide, please. The decision notice will contain a description of the development. Other, not necessarily mandatory, but you'll see them in every single one, is that the result of the decision will be set out, the conditions to the permission should be set out, and the date of the decision. Really, that's the four main elements to every decision notice. The description of the development, however, is usually brief. And therefore, the local planning authority does need a mechanism to bring in extra detail. And this is usually by a list of supporting documents included by way of condition. You'll have seen this, no doubt, if you've been looking at planning permissions. As a planning application is going through the process, interestingly, it's note that significant changes can't be made to the description of the development during the application process. You can't agree with the local planning authority to increase the scope of the development. And the reason for this is reasonably obvious, that the application as submitted is likely to have been consulted upon with the general public, and it's unfair to keep changing that after the date. The local planning authority doesn't have the power to amend the application. It only has the power to grant or refuse it. But what it can do using conditions is limit the scope of the development. So I'm looking at one at the moment with my team where a housing development was described as 1,400 houses, but one of the first conditions actually only limited it to 1,250 houses. There must have been a discussion during the application process about how many houses the site could support. So some of the other mandatory inclusions in a decision notice include reasons for refusal, if it is a refusal. And there are two mandatory conditions. The first is a time limit. You'll commonly see it. This is the permission must be implemented within 3 years, otherwise it is void. And if that, the LPA can decide different time limits, it is allowed to do that. But if the condition is missing entirely, it will be implied by statute. And as of February this year, there was a second mandatory condition, and that is to do with biodiversity net gain. And just before I get onto BNG, leave the slide up, please. One thing one should note is that the conditions to a planning permission shouldn't conflict with the description of the development contained within the decision notice. So an example of this, most simply, is this is a real life example. The description of the development was for 2 wind turbines with a tip height of up to 100 meters. On appeal, the plans contained in the appeal showed wind turbines of 125 meters height, and that was contained in one of the conditions the plans were referred to. The inspector noticed the anomaly and removed the description of 100 meters, sorry, the reference to 100 meters in the description. The court found that A, they weren't allowed to do that. You can't substantially amend the description, and B, had the description remained as it was allowed to, the condition would have conflicted, and therefore the conditions were void. The planning was quashed. Right, the BNG, sorry. The big hot topic of last year, really, but it's come in now in February. So it's a mandatory condition, much like the time limits. It will be implied if it is missing very quickly. Every development, apart from those that are accepted, must show a 10% increase in biodiversity compared to the pre-development on-site habitat. And that condition will say that a biodiversity gain plan must be submitted and approved by the LPA before commencement of the development. Okay, that's all I'm going to say on decision notices for now. I'm going to move on to variations to planning permissions. So in the introductory slide, I said there were 2 ways of varying an existing planning permission. There is on the statute books a 3rd way that's not yet in force. I will very briefly mention it at the end. Between drawing up the slides and today, obviously, it is likely that we're going to end up with what has been announced, that there's going to be a general election, likely to end up with change of government. Goodness knows whether it's ever going to come into force. So let's look at what is in. So first to note that where any proposed modifications to an existing planning permission are fundamental or substantial, a new planning application will need to be submitted. There is no power to make substantial amendments to an existing planning permission. But where there are less substantial changes that are proposed, there are these 2 options. So first is formerly known as a Section 73 application, colloquially known as minor material. And then there is formerly known as a 96A application, more informally known as a non-material amendment. Neither can be used on listed building consents, it should be said. So let's have a look at Section 73 itself. Next slide, please. Whilst it's called minor material in the government guidance, Section 73 itself is entitled Determination of Applications to Develop Land Without Compliance with Conditions Previously Attached. It's clear from the title that there's no reference to minor material. It is just dealing with existing conditions and variations to those. The way, so most minor material applications, Section 73 applications, are for replacement plans. So there is the big advantage of having a list of plans by condition in your original permission, is that containing the detail of the development, is that you can amend that condition, amend the plans referred to, replace them or put in some new ones. So this is the way that one can deal with minor material amendments. So you need to have some material matter in the conditions that you can amend. So the government brought in this concept of minor material amendments after Section 73 come into force, of course. Now, the issue there is that the ability to make an amendment depends upon a relevant condition already being in existence. So if the amendment that you wish to make to a planning permission isn't actually covered by a condition, then there is no route to amending it under Section 73. One could theoretically add a condition, perhaps using the other route in Section 96A that we'll talk about in a moment, and then vary the condition, but we don't see that very often. So on the next slide, we can have a quick look at what the government mean by minor material. There isn't a statutory definition of this, but there is some guidance in the planning practice guidance. So it's any amendment where its scale or nature results in development which is not substantially different from the one that has been approved. There isn't actually a statutory limit on the degree of permissible changes under Section 73, but obviously there is this guidance which has an equivalent force, really. But as we have just seen from Section 73 itself, the change can only relate to the conditions and not the operative part of the permission. You can't change the description of development at the top. Therefore, the variation of any conditions under Section 73 must not result in a conflict with the original description of the development. You just can't change it. So in the next slide, we can see the list of conditions that the LPA can take into account. So it can only look at the conditions. It can't inquire into the background of the permission itself. Provisions relating to statutory consultation and publicity don't apply, so the local authority's got quite a wide discretion about how much consultation it can do. Section 73 can't correct any errors. You can't put back in something that you forgot to put in the first place. There is case law on that where the council forgot to put in the obscured glazing condition and tried to on a Section 73 application, and that was overturned by the court. The High Court, in fact, referred to an old Lord Denning quote: "The planning authority are not at liberty to use their powers for an ulterior object, no matter how desirable that object may seem to them in the public interest." You can quote that at the next LPA that is proving to be a bit difficult. So on the next slide, we can just see that a new, successful Section 73 application ends up with a new planning permission. That means the landowner, the applicant, can actually choose between the two planning applications. So they can still implement the first one. It still exists alongside. Now, there is one little danger in dealing with Section 73s where you've got a refusal and you wish to appeal to the Secretary of State. The Secretary of State's powers are the same powers it has upon appeal for a full planning application. So they have the power to void a planning application. So they can undo the council's original decision. A good example of this was a quarry application, and they applied to vary the condition regarding the road to the quarry. The condition required the road to be improved and brought up to standard, and this was vital for the operation of the quarry. The inspector noted that as the road was not within the applicant's control, it had no ability to make the improvements, the condition itself was unlawful. As the condition was vital for the operation of the quarry, the whole quarry permission was lost. And that was on a result of appeal from a Section 73. So let's quickly look at Section 96A. So this is for non-material amendments. again, there's no statutory definition of non-material. We look at the planning guidance and it just says, well, essentially, it'll be dependent on the context of the overall scheme. So again, the LPA has discretion as to whether to do any consultation. It's likely that there may be none in many changes because by definition, the changes are non-material and therefore shouldn't be affecting third parties. Interestingly, under 96A, the time period for determination is 28 days. Under Section 73, it's because it's an application for a new planning permission, it's the normal statutory time limits of 8 weeks, 13 weeks, etc. Next slide, please. The effect of a 96A amendment is not like Section 73. It's not a new permission. It sits alongside the old permission. It's actually just a piece of paper. It's usually issued by way of a letter to the applicant. So unlike under Section 73, you don't have a choice. Once the 96A amendment has been granted, the old permission should be read as it has been varied. There's no right of appeal from a 96A because of this slightly different format. So your only choice then really is to go for a new permission if it is absolutely required. So finally, Section 73B may never be the new way of dealing with variations. It was supposed to add to the flexibility of these routes for variations. It is in the Levelling Up and Regeneration Act 2023. It's probably not going to come into force now. I suspect there's going to be a larger reform to planning law that will be coming hot on the heels of the general election, but we'll see. The difficulty I had with Section 73B is that the local planning authority should be satisfied that its effect is not to be substantially different from that of the existing permission, which is almost word for word identical to the planning guidance for Section 73 applications, the minor material applications. So the only difference here is that one could tweak the description of the development under Section 73B. Right, and finally, I just left in a slide because I thought it might be interesting to list the sources for these talks. If you ever wondered how on earth I come up with these things, that's not all residing in my head all of the time, unfortunately. For planning law, desperately complicated, which is good for planning lawyers, less for everyone else, but I always like to go to the source legislation, and legislation.gov.uk is now brilliant. It's kept up to date and it's very easy to use. I've mentioned the government's guidance on flexible options for planning permissions. That is also worth a good read. I have a subscription to DCP Online, which is a subscription-only service which takes you through every step of the planning process and is excellent if you're involved in planning quite a lot. And finally, if you're wondering what the old government, now I do apologise, was planning to do, then they did have a consultation up on their website for the accelerated planning system. But that is all from me. So I'm going to hand you over to Rory.
Thanks very much, David, and hello, everyone. My name is Rory, and I'm a Senior Associate in the Commercial Property Department here at VWV. Today, my intention was to give you a brief update on the Leasehold and Freehold Reform Bill, which is currently making its way through the House of Lords and Parliament. A slight disclaimer before we proceed, however. With the announcement of the general election yesterday, this has somewhat thrown the survival of the bill into doubt. With Parliament scheduled to be dissolved next Thursday, we're in that murky period known as the wash-up, when outstanding bills are hastily forced through to make their way onto the statute books. Whether this will be possible with the Leasehold and Freehold Reform Bill is hard to tell. It's a substantial piece of legislation at over 200 pages long, so it could therefore fall before the current Parliament is dissolved. Despite this, I think that the principles contained within the bill and the issues that I'll discuss today are still relevant going forward, and in any event, another government may go even further in attempting to amend or abolish our leasehold system. Next slide, please, Beth. So firstly, I thought it'd be useful to give you a quick refresher on what leasehold and freehold actually are. Property in England and Wales is owned essentially either as freehold or leasehold. In the most general terms, freeholders own both the property and the land that the property is on, essentially in perpetuity. Leaseholders, on the other hand, own their property for a fixed amount of time, leasing it from a third-party landlord. That landlord might be the ultimate freehold owner of the land or the buildings in question. With leasehold interests, ownership of the property then reverts back to the landlord when the lease comes to an end. Unless in the context of residential properties, the leaseholder pays to extend their lease and increase their period of ownership, they're no longer entitled to possession of the property following expiry of the lease term. The leasehold sector represents 1 in 5 properties in England and 1 in 6 homes in Wales, so a significant amount of homeowners are leaseholders. So what is the government trying to achieve with this bill? Next slide, please. Well, due to the different characteristics of freehold and leasehold tenures, many feel that in recent years, leaseholders have been subject to unfair practices, putting them in a less favourable position to those who own freehold properties. Under the government's impact assessment bill, published as part of the bill, they summarise that while many landlords will provide adequate service for a reasonable cost, there is growing concern that the current legislation leaves leaseholders exposed to the risk of abuse and bad practice. It is difficult for leaseholders to enforce their rights to tackle these issues, such as a significant lack of transparency over charges they're required to pay, escalating ground rents and unfair lease terms, as well as limited access to redress and an unequal liability to cover legal costs in disputes. The Leasehold and Freehold Reform Bill therefore aimed to deliver on the government's manifesto commitments by making it cheaper and easier for more leaseholders to extend their lease, buy their freehold, take over management of their building, and buy out their ground rents. These manifesto commitments stretch back to 2019, with several acts having come into force since then. Next slide, please. Such as the Building Safety Act 2022, which sought to remediate historical building safety defects following the Grenfell Tower disaster, and the Leasehold Reform Ground Rent Act 2022, which restricts ground rents for most new long residential leases to a peppercorn, or in other words, prevents landlords and developers from charging ground rents under new leases. Next slide, please. Many argue that ground rents are essentially money for nothing and do not provide leaseholders with any particular benefit. They are distinct from, and not to be confused with, service charges, which are the costs that a landlord can recover from tenants for providing services to benefit a property. Restricting ground rents in all new leases did not, however, address those existing leases granted before the 2022 Act, under which ground rents are already payable. So there are a significant number of leaseholders who are still required to pay ground rents, some of which, as I'm sure you might be aware, are onerous. The government's manifesto commitment back in 2019 was to abolish all ground rents, and the bill in question initially sought to reduce all ground rents to a peppercorn. This has not transpired, and while the current iteration of the bill does not abolish all ground rents, it does seek to introduce a number of other significant changes to the leasehold system. Firstly, next slide please, sorry. Firstly, increasing the standard lease extension term for houses and flats to 990 years, up from an existing 90 years in flats and 50 years in houses, with ground rent reduced to a peppercorn upon payment of a premium. This is to provide leaseholders with secure long-term ownership of their properties without them having to worry that ownership will revert back to the landlord at the end of the original term, and without the hassle of repeated lease extensions. Secondly, removing the so-called marriage value, which makes it more expensive to extend leases when they're close to expiry at 80 years or less left on the lease term. Thirdly, requiring landlords to provide property information to tenants within certain timeframes when a tenant requests this in order to sell their property. This is to reduce delays many have experienced during the conveyancing process, trying to get information from landlords. Fourthly, replacing buildings insurance commissions for managing agents and landlords with transparent administration fees to prevent any abuse of leaseholders being charged excessive, obscure commissions on top of their premiums through their service charge payments. Fifth, banning the sale of new leasehold houses so that, under exceptional circumstances, every new house in England and Wales will be freehold from the outset. There seems little need to sell houses on a leasehold basis, and I think that the market has actually already shifted away from such practices in recent years, largely due to it attracting a lot of negative press. So I think this is quite an easy win for the government, but one which is overdue, many would argue. Next slide, please, Beth. A final key term of the bill is introducing the right for a tenant of lease with an unexpired term of 150 years or more to vary their lease to pay a peppercorn rent. Effectively, these provisions enable a leaseholder to buy out their ground rent without extending the term of their lease or buying the freehold. The reason for this is that some leaseholders may have a sufficiently long lease and do not need or wish to extend their term, though they have a desire to buy out their ground rent, particularly where this is or will become onerous. In order to buy out their ground rents, however, the tenant will need to pay the required premium, which in summary will equate to the value of the landlord's right to receive ground rent over the remaining term of the lease. Such sums could amount to tens of thousands of pounds. So while the possibility of leaseholders being able to buy out their ground rents and enjoy ground rent-free leases sounds appealing, in reality, the cost of doing so will be significant and, I imagine, in many cases, prohibitively expensive. Next slide, please. These are just a few key examples of the proposed changes that the bill was intending to bring about. But if the bill were implemented in its current iteration, how would this affect our esteemed guests and viewers? Well, firstly, if you own leasehold property and you're affected by some of the issues I've outlined, then it would be wise to review your lease and consider whether you could extend the term, buy out your ground rent, or perhaps seek to acquire the freehold. You would be in a much more favourable position to do so going forward. On the other hand, if you're a landlord or a developer and deal with leasehold disposals regularly, then you may wish to review your standard form leases and the terms on which your leases are usually granted. Could these amendments proposed by the bill lead to a general trend in the market granting longer term leases, say 9-year leases, for example? If this bill or a similar bill were to pass, it would then be wise to review your obligations as a landlord so you don't fall foul of your requirements if you're faced with a leaseholder seeking to enforce their new rights. It's also worth noting that in many instances, landlords will no longer be able to recover their costs from leaseholders when they make such requests. So these costs will ultimately be pushed back onto freeholders and landlords. Next slide, please. While we'll need to wait and see, therefore, how effective such amendments will be in practice, if in fact they are ever implemented, most would agree that these changes will put leaseholders in a more favourable position. But despite these changes, the bill does not go as far as some were originally led to believe, particularly with respect to abolishing ground rents in existing leases. So what is preventing ground rents being abolished in their entirety? Well, the government has faced opposition from landlords of all shapes and sizes, from individuals who have bought ground rent portfolios as part of their retirement plans, to large institutional pension and investment funds, whose long-term investment strategies include the collection of ground rents. Many of these institutional investors will be the ultimate freehold owner and landlord to many residential properties throughout the country. The general thrust of the opposing argument is that the government, by legislating to abolish ground rents, is interfering with property rights acquired by individuals and companies under contracts entered into in good faith. The government has therefore had to consider various human rights implications arising from the proposals in the bill, particularly Article 1 of the first protocol to the European Convention on Human Rights. This provides that persons, both natural and legal, have the right to peaceful enjoyment of their possessions without interference from the state and without fair compensation. Many of the proposed amendments in the bill engage Article 1, and so the government has had to carefully consider and balance these proposals against interference with property rights. If the government legislated that all ground rents were worth just a peppercorn, for example, This would then render those ground rent portfolios completely worthless. Unless a satisfactory position can be found, therefore, which adequately compensates landlords for the loss of ground rent payments, it will be difficult for a government to abolish ground rents completely. So, given all that, and that the bill may not eventually make its way through Parliament now, what does the future hold for leasehold reform? Next slide, please, Beth. Despite the extensive amendments proposed by the bill, there are some who argued that the changes did not go nearly far enough. There was talk within the Labour Party last year, for example, of abolishing the leasehold system in its entirety within 100 days of coming into office. As far as I'm aware, I think this pledge has been quietly dropped since then. But even Michael Gove, who introduced the bill, has described the leasehold system as an outdated feudal system. Regardless of what you call such a system, though, there has to be some way of dealing with shared ownership of property in which multiple people have an interest. How that shared property is maintained and administered will need to be carefully considered. And while the current leasehold system may have flaws, abolishing a system without ensuring that a suitable alternative is in place will introduce its own problems. But are there any existing alternatives which we could look to? Well, attempts at implementing alternative systems have been made before. The introduction of common hold in 2004, for example, which is a form of freehold land ownership in England and Wales. It was recommended based on the experience of other countries and jurisdictions where land holdings, similar to common hold, had operated successfully for decades. It provides ownership of land rights and control to the individual owners as common holders, who collectively manage and maintain the property through a common hold association, which appoints a professional managing agent. There is no separate freeholder landlord. However, the take-up of common hold in England and Wales has been very low since it was launched 20 years ago. This lack of popularity seems to have a number of causes, including the slightly cumbersome approach to creating common holds, market inertia, and an unwillingness by some lenders to offer mortgages on common hold titles. Some therefore point to common hold as being a suitable alternative to leasehold already in place or in existence. The key issue seems to be finding a way to increase uptake and making the system more attractive to the property industry. However, with the general election now set to take place on the 4th of July and the prospect of a new party taking power, we could be in for further significant changes to our leasehold and freehold system. So we will be monitoring the situation and any new developments very closely. But I hope that I've at least given you a taste of what these changes could be, and also provided an interesting current example of when competing politics, industry pressure, and various opposing interests all intersect to shape and mould our new laws. If anyone has any questions, I'd be happy to do my best to answer them at the end of the video. Otherwise, I'll hand you over to the capable hands of Rebecca Hill.
Thank you, Rory. Hi, everyone. My name is Rebecca Hill, and I am an associate here at VWV in the commercial property team in our Bristol office. In this section of the session, I'm going to provide an update on two recent cases, one concerning easements and the other concerning restrictive covenants. Next slide, please, Beth. So the first case concerns the law of easements. This is the recent High Court judgment in South Tees Development Corporation and PD Teesport Limited. The case touches on a number of interesting aspects of the law of easements. There's no new law in this case, but it is a useful reminder of making sure potential rights for neighbouring land are always considered when you're acquiring land for development. The judgment was handed down on the 5th of February 2024 following a 6-week trial in October and November 2023. The judge found in favour of the Teesport operator on 6 out of 18 claims that were under dispute. An easement, so a right for the benefit of one parcel of land over another, can be created in a number of different ways, and this case addressed the express grant of an easement by deed, claiming a right by prescription, broadly being the continuous exercise of a right for 20 years, and obtaining an applied easement and right of way. Next slide, please. The case concerns the former British Steelworks on Teesside, which is the largest brownfield site in Europe, by the South Tees Development Corporation, who are a mayoral development corporation and the first outside of London, and the Teesworks Limited, who are a joint venture company involved in the development, over which rights were claimed by PD Teesport. The case centred on a right-of-way between Fisherman's Crossing and South Gare Road, which extends across the former SSI Redcar steelwork site. The site is controlled by the claimant, but it includes elements owned by the defendant, such as the Redcar Quay and parts of Teesport itself. Describing the case in his judgment, Mr. Justice Raja said that the claimant brought the proceedings seeking negative declarations that the defendant did not enjoy any rights of way across their land, and the defendant launched a counterclaim arguing it had prescriptive, express, and implied access rights. Next slide, please. While only 6 of the defendant's 18 claims were upheld, it was established that the company had the right to access South Gare, Redcar Quay, and South Bank. The defendant claimed express and prescriptive rights over the claimant's land to access 3 areas which it owned and maintained. It failed to establish express rights, but it did establish these rights by prescription based on documentary evidence available and testimony of witnesses at the former steelworks. The claim for an implied right-of-way concerned access to and from Redcar Quay. To get to the highway from Redcar Quay, the defendant had to pass over the claimant's land. The High Court found a common intention in a 1971 conveyance that Redcar Quay would be used as a quay, and therefore a reasonable person would conclude that there should also be access to operate Redcar Quay over the claimant's intervening land. Some commentators have been critical of this matter ending up in High Court due to the costs involved, especially with the claimant being a publicly owned body. But others highlight that the decisions led to much needed clarity over what rights the defendant has over the Redcar site, which will enable the claimant to accommodate them in their master plan for the development. Next slide, please. So this judgment addresses a number of significant issues on the law of easements, which are of interest for property practitioners. The first being that the case is a good example of commercial entity claiming rights of way by prescription, as well as an analysis of what's required for use to be by permission. PD Teesport were successful in claiming rights by prescription to 2 locations, relying on a mixture of witness evidence, documentary evidence, and inferences. The second is that PD Teesport were successful in obtaining an implied right of way to access land, which was intended to be a quay when it was acquired. This case therefore provides an interesting worked example of how implication by common intention can be established by parties who are lacking express grants of rights of way. And the third is that the judgment grappled with a number of difficult issues in relation to a compilation of express grants and provides confirmation that if the dominant tenement of a grant of a right of way is itself a road, then the grant can be used to access other land beyond the dominant tenement as an exception to the rule in Harris and Flowers. The case therefore emphasizes that developers and their advisors should be vigilant when acquiring land. Neighbouring property may benefit from rights of way, which might be significantly impact the design and the viability of a development. Such rights might not be discoverable on a mere title review, and the site should be carefully inspected to discover any evidence of rights being exercised. The case also shows the effectiveness of witness testimony from locals in establishing a prescriptive right. 34 witnesses provided evidence to the court in this case, supporting the defendant's claim that it had multiple rights of way over the Redcar site. Gathering all the evidence would have been no mean feat, but ultimately it proved successful for the defendant in the High Court. The judgment also contains a helpful summary of the current judicial approach to witness evidence more generally. Next slide, please. So the next case that I was going to talk about concerns restrictive covenants. In this case, it was an application to the Upper Tribunal Lands Chamber brought by Mrs. Susan Margaret Gull. The tribunal discussed whether a restrictive covenant, which prevented the conversion of an agricultural barn into a residential dwelling, could be modified under the Law of Property Act 1925. The applicant purchased a cottage in 1987, within the grounds of which there was a barn, which was used for agricultural storage. The applicant wanted to develop the barn into a 3-bedroom property for her children, and so in 2015, an application for planning permission was made. Planning permission was granted in July 2015, together with the necessary approval for a change of use of the land. However, the development could not proceed because of restrictive covenants created in the original transfer of the land back in 1987. The applicant had covenanted with the then owners of the neighbouring properties and expressly with their successors in title not to build on the land without their consent, which was in clause 6.1.1, not to use or permit use of the land for any trade or business, and to use the land as a single private dwelling house, grounds and outbuildings, which was in clause 6.1.4. The neighbouring properties included a large detached period property with extensive grounds, which was Cowden Hall, and 2 other properties which comprised a total estate of 90 acres. The estate also incorporated a private driveway used to access the applicant's property. Next slide, please. In September 2017, Mrs. G applied to modify Covenant 6.1.4, which was to only use the land as a single private dwelling house, grounds and outbuildings, pursuant to grounds A and C of Section 84(1) of the Law of Property Act 1925. But the new owners of the neighbouring properties objected to the application. The objection was made on the basis that the planned development would cause a significant loss of amenity, including in terms of noise, access and traffic along the driveway, smoke and fumes, visibility and amenity within the gardens and grounds. It was agreed that the value of the estate with the benefit of the covenants was 2.6 million, and the proposed development would have a diminishing effect on the value in the region of 2.5% or £65,000. The grounds Mrs. G relied on to modify the restrictive covenants were 84(1)AA, that the continued existence would impede some reasonable user of the land for public or private purposes, or as the case may be, would unless modified so impede such user, and 84(1)C, that the proposed discharge or modification will not injure the persons entitled to the benefit of the restriction. Next slide, please. The Upper Tribunal had the discretion to modify the restrictive covenants if grounds AA or C were made out and the Upper Tribunal was satisfied that the restriction in impeding that user, either 84(1)AA, does not secure to persons entitled to the benefit of it any practical benefits of substantial value or advantage to them, or 84(1)AB is contrary to the public interest, and that money will be an adequate compensation for the loss or disadvantage, if any, which any such person will suffer from that discharge or modification. Next slide, please. It was held that a diminution in value in the region of 2.5% was not considered substantial, and although £65,000 was generally considered a significant sum of money, it was less so when dealing with an estate that's worth 2.6 million. As a result, it was considered that the objectors could be adequately compensated with money, and that the court therefore used its discretion to allow the modification of clause 6.1.4 in order for the development to proceed. This case arguably demonstrates that landowners with the benefit of restrictive covenants are arguably becoming less able to rely on and enforce them, where a modification or a breach can be compensated with money. The tribunal will consider other factors, such as how long ago the restrictive covenant was entered into and whether the parties are the original covenantee or covenantor, but it's unlikely that those additional factors will have any significant effect on the outcome in this type of matter. And next slide, please. And that's it for me. So I think if there are any questions in the Q&A box, we can each pick up those as they come in. Thank you, everyone.
Thanks so much, Rebecca. So if you've got any questions, please stick them in the box. Or, in fact, fire them over the email to us if you think of them later.
I've had a question raised about the Renters Reform Bill and how it relates to the Leasehold and Freehold Reform Bill.
Rory, you sound very distant, Rory. Is your microphone in the right place?
Sorry, is that better?
Mm-hmm.
Yeah, sorry. No, I've had a question about the Renters Reform Bill and how it relates to Freehold, the Leasehold and Freehold Reform Bill. Essentially, that is a separate bill that's also making its way through the House of Lords and Parliament at the moment, and that deals separately with issues in the private rented sector. So most notably, it will introduce the abolition of Section 21 notices, and also the abolition of fixed term residential tenancies. But again, you know, it's at a slightly earlier stage in the Leasehold and Freehold Reform Bill, so who knows what will happen. And Graham has also asked a question about the Leasehold and Freehold Reform Bill. Is at a report stage in the Lords. What are the chances of it being part of the wash-up? Well, I think that's a very good question. I think it's quite hard to say at this stage. As I said, it's a very substantial bill. There's a number of other bills going through, Renters Reform Bill, for example, and with Parliament set to be dissolved next Thursday, whether they have enough time to actually get that pushed through, I don't know. It's probably quite unlikely. But yes, so it's at the report stage. I think there's a third reading after that. It then has to go back to the House of Commons, provided everyone agrees. So yeah, there's a lot of work to do.
Cool. I've got one on the planning side. What are the ramifications if a decision notice wrongly identifies something in its reason for refusal? If it has been refused, then the only route is to appeal, even if the reasons in the refusal are wrong. There's no point in considering JR, for example. So if it were passed for the wrong reasons, one would consider judicial review because the process was wrong, but an appeal is going to be, the courts would always defer to the right of appeal first. So I'm afraid that that's trotting off the pins. Cool. Have we got any more? Give it a few seconds longer. And oh no, okay. Well, if we got no more questions, then we'll do the feedback poll and wrap up. As I said, our details are on screen. The slides will be sent out separately shortly. Please check out our website or sign up to our mailing lists for more information about things like this on a variety of subjects. So yeah, please fill out the poll and thanks very much. Oh, hang on, we do have one question, Rory. You want to grab that whilst people are doing the poll?
So Graham has again asked, if the Leasehold and Freehold Reform Bill is killed off, will it start from scratch again or bring it back with the amendments? So I mean, my understanding is that if it isn't pushed through during the wash-up, then it falls as a bill, and then it has to start again under the new parliament, under the new government. whether the new government will want to bring it back in its existing form, we'll just have to wait and see. But I think many of the issues that it addresses are probably not party political. I think, you know, they're probably both parties agree that they're needed. So, but I think personally for me, it's whether a Labour government will go further in amending the leasehold system and what those amendments could be. I hope that's answered your questions.
Good question about parliamentary law there, isn't it? It's the end. It is the end of a parliament, isn't it? So all bills in process are killed off, aren't they?
Yes, because I was, with the election announced yesterday, I was frantically trying to revise my knowledge of public law and parliamentary processes. So